ICC prosecutor Fatou Bensouda is no doubt relieved that the trial chamber judges by majority have granted her request to have the 8 Kenyan witnesses who had refused to testify compelled to do so. During a status conference held on Valentine's Day this year, the Attorney General had stated that such a request would be impossible to grant.
The government of the Republic of Kenya cannot, without violating the Constitution, compel any person who does not volunteer to be a witness to become a witness.
But the judges in their decision today directed the registry of the court to prepare and transmit a cooperation request to the Republic of Kenya for the service of summonses by the government of Kenya on these 8 witnesses, for the assistance in compelling and ensuring the 8 witnesses' appearance before the chamber by video link or before the chamber convened on the territory of Kenya, and for the government of Kenya to make appropriate arrangements for the security of the 8 witnesses until they appear before the court. The chamber found that the government of Kenya has an obligation to cooperate fully with the court by serving the summonses to the witnesses and by assisting in compelling their assistance before the chamber by the use of compulsory measures as necessary. This, however, is a position that drew a heated legal battle in this courtroom during the status conference.
If the witness is within the territory of the Republic of Kenya, the answer is no. That witness is not compellable by you and is not compellable by us.
We're not asking for the witnesses to be sent out of Kenya to The Hague.
What we are suggesting is that the notion of testimony via video link and the ability to compel somebody is a different assistance type to requesting a witness to go abroad.
It makes no difference if a witness is from Timbuktu and appears by video link. That witness is appearing before the court.
The chamber felt that the Rome Statute state parties did not intend to create an ICC that would be powerless to summon witnesses. But the Attorney General and the defense teams had earlier argued that the Rome Statute provided only for voluntary testimony.
There cannot be a threat that if witness X does not accede to the requirement or the order of the court, that the witness can be incarcerated, deprived of their liberty, bundled into a van and taken to a location.
As you do know, sir, the witnesses before this court are not known by the Kenya government at all. We cannot put a name to any person. We have never been part of the process of discovery. To the extent that the Kenya government is aware of any witness, it's the witnesses that have already testified, and most of them have done so in camera in this chamber. How did they arrive at The Hague? We don't know.
If someone is willing, there's no problem. There's no problem requesting a witness to testify, to submit a summons, and if the witness is willing, then there's no issue. But if the witness is unwilling, then you need an authority, a force, a power to compel this witness.
The trial will resume next month as the trial chamber is currently on an Easter break. Sylvia Chebet, Citizen TV.